Welcome to the Orleans County Corruption Brady List. Today we're going to be exposing Anthony Bruce. My tactic in bringing Anthony Bruce to justice has been basically to get Mr. Bruce to respond. And in doing so, we've caught him here. In this document, we catch Mr. Bruce falling on his own sword, if you will. And I'll just get right to it. This is a response from Mr. Anthony Bruce, Special Prosecutor in Orleans County, and he's responding to my argument. And Mr. Bruce here, he's admitting some very interesting things. So I'm going to narrate real quick. Please bear with me because there's a lot we're going to be pointing out. As noted in our original response, the defendant was charged in a felony complaint dated June 16, 2022. He was indicted in that case on August 18, 2022. He was arraigned on September 14, 2022. Thereafter, on October 5, 2022, the people filed both a certificate of compliance and a statement of readiness, copies of which were attached as Exhibits 1A and 1B to our response to the defendant's omnibus motion. That case was dismissed on February 19, 2023, based on the fact that the undersigned did not live in or have an office in either Orleans County or an adjoining county as required by county law subsection 701 when the undersigned presented the case to the grand jury. Number 3, at the time the court dismissed the case, it sealed the file. In moving to dismiss, the defendant, in essence, dismisses the statement of readiness filed in that case, arguing that the undersigned's authority to file statement of readiness suffered from the same geographical infirmity, as did the undersigned's authority to obtain the original indictment. The problem with the defendant's argument is that it is a clear case of the defendant trying to have his cake and eat it too. Number 4, in his motion to dismiss the original indictment, the defendant argued that, given the undersigned's failure to comply with the geographical requirements of county law subsection 701, the undersigned was acting ultra vires in presenting the case to the grand jury and returning that indictment. This made that indictment a nullity, which required the court to dismiss it, which, on the defendant's motion, the court did. The defendant now argues that October 5, 2022 statement of readiness was also a nullity. However, to make that argument, the defendant, as he must, has to rely on the fact that the September 18, 2022 indictment was a legal nullity. That means that it was unlawful and it lacked authority. Number 6, however, if that is the case, not only was the undersigned's actions of presenting the case to the grand jury and returning the indictment ultra vires without authority, in actuality, the case never existed. And any additional acts the undersigned took to advance that case, including filing the October 5, 2022 notice of readiness, were likewise done without authority. In short, the indictment never happened, and the people had no obligation to declare their readiness for an indictment that did not exist. Wow. Number 7, however, the defendant's argument requires the existence of a legally sufficient indictment for which the people then filed a legally insufficient statement of readiness. Having successfully argued that the September 18, 2022 indictment was legally insufficient due to the subsection 701 issue, the defendant cannot now have his cake and eat it by arguing that the September 18th indictment was legally sufficient. The prosecutors admitted the indictment was insufficient, it was without authority, and that it never existed. The indictment did not exist is Bruce's position now. Number 8, As we also pointed out in our original response, the first indictment was dismissed on February 19, 2023. That date is wrong. It was February the 9th, 2023, when Bruce became unauthorized and admitted he wasn't authorized in front of Judge Church, February the 9th, 2023. We'll go over that document in a minute. The first indictment was dismissed on February 19, 2023 because of the subsection 701 issue. However, that indictment was not dismissed on 3030 grounds. If that had been the case, that dismissal would be binding on the court and the parties in this case. How would that be binding, Mr. Bruce, when the indictment was never even valid? The indictment you're saying here doesn't exist because it never happened. How so would this 3030 motion be binding if that case was unlawful, sir? The problem with the defendant's argument is that no 3030 motion was made, much less granted, in the prior case, so there is no ruling on that motion that might bind the court and the parties in this case. Yeah, this guy's nuts. Number 10, that case and the opportunity to file a 3030 in it has come and gone, and the file is sealed. In short, we submit that the defendant waived any speedy trial motion in the prior case, and therefore that case has no bearing on this case. Then why are you talking about it, Mr. Bruce? Conclusion: for the reasons stated in this memorandum, in our original response and in our rebuttal, the defendant's motion should be denied in all respects. Dated May 31st, 2023, Anthony Bruce. Yeah, so during this period of prosecution by Anthony Bruce, not only was the indictment without authority and invalid, that means the whole case, everything here Bruce is admitting was insufficient and that it lacked authority. Guess what else that means? That means that Bruce wasn't qualified. And it also means during this prosecution in open court in front of Judge Sanford Church under the color of law, Prosecutor Bruce wasn't qualified, which also means he doesn't enjoy qualified immunity, which is one of the elements I will be suing Mr. Bruce on, that illegal and lawful prosecution under the color of law in front of Judge Church, which drags Orleans County into this new lawsuit as well. So there won't be any immunity problems, Mr. Bruce, Mr. Professor, Mr. former U.S. Attorney. And we're going to talk about some other stuff here. And there's some information here if you want to read it. It's plastered on my page. But it involves pretty much all of the corruption of Anthony Bruce and all of the victims of Anthony Bruce's illegal prosecutions and perjury. It's all coming to a head, and Mr. Bruce has responded. He fell for it, and now we're going to talk about some documents that Mr. Bruce stole from Michael Keefe. Mr. Bruce responds to my allegation that he stole documents in this email from Anthony Bruce, who writes, "In his attempt to shop for another prosecutor by trying to grieve me, he does not grasp at least 5 things. Even assuming his grievances had merit to the degree that the grievance committee recommended my disbarment to the 4th Department, the grievance committee would not act for many, many months, and the 4th Department would not act for many months after that, to a point well past the conclusion of his trials." Let's look down here at number 5, and I'll pull that up even. We can pull that up even better right here. Number 5, even if Mr. Ortiz and by extension Michael Keefe is factually correct about my snatching records at his Judge Moore trial, I would not be disbarred. So let's take a look. And here's the hindering: no minutes, transcripts of the trial before Judge Moore presently exist. And I doubt the PD's office would authorize expenditure of funds for those transcripts so Mr. Ortiz can get them to the grievance committee. But he can ask, wow, So here's the point I want to get to is that Mr. Bruce says that he did snatch documents, but that the Attorney Grievance Committee wouldn't act for a certain amount of time. And part of those documents are right. And in this document, sworn under the penalty of perjury, Mr. Bruce responds May 12, 2023, after I file a habeas corpus. Mr. Bruce claims in his habeas corpus that Berrytown Court cannot supply these transcripts. Legal Aid of Buffalo, which represents Ortiz, have the transcripts of the November 21st trespass and bench trial in the Albion Town Court, where I did not take documents from Mike O'Keefe. So we got Bruce to respond in this sworn affidavit under the penalty of perjury that Mr. Bruce's response is that he did not steal documents from Mike O'Keefe. However, we do have the minutes of Mike O'Keefe advising Judge Root about that theft. And here are those minutes. And in these minutes, we can see there comes a period at this trial when I have a conflict with my attorney, Mr. Baisley. And sitting in the audience is Mike O'Keefe watching Prosecutor Bruce, because Mike O'Keefe knows Prosecutor Bruce isn't authorized to prosecute me. And then the court sees Mike O'Keefe and the court addresses Mike O'Keefe in the audience. The judge says, "The individual sitting there, Mr. O'Keefe, at one time you were the attorney of record for Mr. Ortiz." Mike O'Keefe responds, "Yes, sir." The court, "Okay, I know this is asking a lot. Would you be able to sit in while I do questioning of the jury after lunch?" Mike O'Keefe, "No, sir. I would not be able to do that. My apologies. I particularly would not take any standing in or assignment or have anything to do with Mr. Bruce, as he has stolen files from my folder and he's threatened me. And in fact, if I were to say anything, he should be recused." The court's response, "Okay, thank you." Mike O'Keefe's response, "Thank you." My response, I immediately object. "Your Honor, I would also like to say that I would like you to be recused from this case, and I've asked in the past and I have a problem communicating with my lawyer." So there was a problem with me communicating with my lawyer because every time I asked him for a recusal of the judge would say no. But here we clearly see an attorney reporting a criminal act by Prosecutor Bruce, who stole documents from Mike O'Keefe and threatened him. Those are crimes. And the judge did nothing about it at this time other than say thank you. And he didn't address it. He did not address those crimes that was just reported to Judge Root. So we can see in this sworn affidavit by Anthony Bruce that he lied. He said he did not take documents from Mike O'Keefe, yet he admits to it in the response to my complaint to the Attorney Grievance Committee, and he responds that even if it was factual, that the Attorney Grievance Committee wouldn't act in many, many months. Also, we're going to be talking about a letter from D.A. Cardone. Right here we have a letter about more lies. So this is an affidavit from Joe Cardone, the District Attorney of Orleans County here. And it says basically, "I'm giving this affidavit in support of the simultaneously filed response to the defendant's supplemental pretrial motion and in response to the defendant's previously filed omnibus motion. And I am familiar with the parts of those motions that are pertinent to this affidavit." Take a look at this. So at paragraph 11 of the defendant's October 31st, 2022 omnibus motion, the defendant states that upon information and belief Mr. Ortiz did have meetings with the DA on June 13, 2022, and discovery is demanded regarding the times Mr. Ortiz was present at the DA's office, the extent of the conversations, and any notice related to the complaint made by Mr. Ortiz on June 1st. At paragraph 18 of the defendant's December 2nd, 22 motion, the defendant by counsel asserts that based on his review of the dump from the defendant's cell phone that was seized from the defendant on June 13, 2022, there are a few video clips which show Mr. Ortiz walking over to the DA's office. The video directly contradicts Mr. Bruce's unsubstantiated claims that there were no conversations or notes related to this claimed interaction between Mr. Ortiz and I. On June 13, 2022, I was present in my office when I became aware that Mr. Ortiz was in the public safety building, in which both my office and the Orleans County Sheriff Office are located, and that he was making various demands of the Sheriff's Office. My recollection is that at some point, Mr. Ortiz did present himself at the reception's window in the waiting room of the district attorney's office that day and was insistent with my secretary that he be able to speak to me. In response, I did meet Mr. Ortiz at the window. Mr. Ortiz was insistent that he be provided with discovery paperwork with respect to his pending charges, and I explained to him that those materials are provided to his attorney through the special prosecutor assigned his case. To the best of my recollection, that is the entire extent of my contact with Mr. Ortiz, and there were no other meetings, recordings, or notes made as to the limited contact I had with Mr. Ortiz. So Mr. Bruce, he indicated that I didn't have any business at the public safety building the day that I was arrested when I was charged with felonies. And so here's Mr. Bruce. But to confirm our discussion of this morning, there was no June 13 meeting, discussion, or interaction between or among Mr. Ortiz and anyone from the DA's office, which moots paragraph 11 of your motion. And 2, the public safety building video of the event of June 13 was recorded over, as is done with all surveillance footage from the public safety building, and was thus not preserved and is therefore unavailable. This moots paragraph 9 and 10 of your motions. From Anthony Bruce. This video was of my arrest, where the undersheriff takes my phone, smashes it, steps on it. They drag me to the back of the public safety building, and they chain me to a chair for over an hour, and they refused to let me have any water or to use the bathroom. And it was a Thursday, one of the hottest days of the year, June 13th. And it was like 100 degrees out. So I was well hydrated and had to pee really, really bad. And they forced me to urinate in my pants. It was that bad. And that video, if it would have survived, would have showed all that. But it didn't survive because Mr. Bruce saw to it that it was deleted. So Mr. Bruce's allegation that there was no meeting or discussion gets contradicted by D.A. Cardone in this affidavit right here, where D.A. Cardone says that on June 13th, there was an interaction between him and myself, which I just read. And that arrest, the video being deleted, it was supposed to be preserved. And if I was acting like such a big bad terrorist, why would the sheriff's department allow it to be deleted? How could it be recorded over if I was in the public safety building acting like a big bad terrorist? Why would they delete it? That's interesting. The big point here in this corruption is the fact that before January the 5th, 2023, Anthony Bruce did not have an office or an office in Emerging County with Orleans County. Prosecutor Bruce was outside of County Law 701 and County Law 701 subsection 215, which he's still in violation of, which means if Anthony Bruce prosecuted you or you were indicted by Anthony Bruce, before January the 5th, 2023, your indictment never existed either, and is insufficient and never happened. So People versus Harding never happened as well. And Anthony Bruce admits that he did prosecute outside of the law, right? Ultraverse, right? Ultraveres, yeah. Anthony Bruce also created this document for Maureen Beach to sign, where she perjures herself. This is a motion for an order to show cause by Maureen Beach, who alleges that at approximately 11:25 a.m. on March the 6th, Ortiz, whose voice I readily recognized, called the clerk's office. In substance, he pressed me for the contact information for the court reporter. So she's saying that I called her up March the 6th and that she knew my voice. Well, I took this matter and I had Maureen Beach get on the stand and under oath, where my attorney asks Maureen, "Are you absolutely sure the person you spoke with on March the 6th was Mr. Ortiz?" Answer, no. So Maureen Beach says no here while on the stand and under oath. You know, this document that she signed was created by Anthony Bruce. And we'll even keep reading. The phone call on the 6th was the subject matter of the same subject matter as the meeting on the 2nd. Answer, yes. Question, and what did you conclude from that? I concluded that it was Mr. Ortiz. Concluded. So, miss, that affidavit in People's Exhibit number 3, I believed it is. Do you recall a portion in parenthesis that says Mr. Ortiz in parenthesis, whose voice I readily recognized? Do you remember that in the affidavit? Whose voice I readily recognized, correct? That was in the affidavit, correct? Answer, I don't know. I would have to see the affidavit again. And you stated in that affidavit that Mr. Bruce created, that you reviewed for accuracy, that you reviewed for truth, that you signed, that you readily recognized his voice, correct? She answered, yes, that's what she signed. But you didn't, did you? You already stated that you didn't, ma'am. Answer, I don't recall. Well, Mrs. Beach perjured herself too. All roads lead to Bruce. All roads lead to Anthony Bruce. And that road landed me in jail on contempt of court because Bruce guided the judge and advised the judge that the judge could put me in jail for contempt of court. Yet there's no class, there's no subdivision, there's no specificity here specifying exactly how am I being held in contempt of court? Is it civil contempt, criminal contempt? And basically, that's pretty much it. Well, I found another document here. It's an affirmation in support of supplemental motion. And it's part of Special Prosecutor Bruce acted as an unsworn witness to the grand jury. Anthony Bruce told, when talking to the grand jury, to address their fears that Mr. Ortiz would retaliate against them for their role as grand jury. Special Prosecutor Bruce tells the grand jury that Mr. Ortiz has gone after him repeatedly to attack his ability to practice law. The New York Court of Appeals has held that when there is not an isolated instance of prosecutorial misconduct and where the prosecutor acted as an unsworn witness, Prosecutor Bruce acts as an unsworn witness and has the audacity to tell the grand jury that I'm going to come after them for being grand jurors. I mean, this guy knows no bounds. And as the public defender sits there at a pay rate of $95,000 plus a year, she does absolutely nothing about this, and I bring it to her attention. You see, the pattern here is the problem with getting court records. And right now, I'm trying to get records from the court to perfect an appeal, and the court is refusing to provide me those records. And I'll give Mrs. Best this much. She at least emailed the court. I understand that Abigail Whipple from the Legal Aid Bureau of Buffalo has been assigned on the appeals related to the Ken Ortiz matters in the town of Albion with Judge Moore. She has not yet received certain documents, including exhibits. As you are aware, there are very specific time limits related to appeals. Please provide these documents to her so she may complete the appeal. Let me know if our office can assist in any way. This was sent May 16, 2023. I'm going to need a third extension to perfect my appeal because the court is refusing to, as of this day, June the 3rd, 2023, the court is refusing to hand over records. Do police officers lie? Yeah, they do lie. And we're going to take a look at one officer here. I was dispatched to Walmart for a disturbance call involving Ortiz. Do you know who the dispatcher was? I believe it was Alan Turner. Okay, and they said that there was a disturbance that day? Answer, correct. Okay, now we know that was a misstatement. Answer, okay. Question, it was a lie? Mr. Bruce, objection to the use of the word lie. Mr. O'Keefe, he already ruled in my favor. Yes. It was a lie? Answer, yes. This is police officer, sheriff deputy Ambrose. He said it's a lie. It's a lie. And what was a lie? The disturbance. And the disturbance being when? Earlier that day. Okay, all right. Now after that fact, you understand it that the disturbance wasn't earlier that day. Correct. Okay, so in fact, it was a lie then. It was a lie. The Deputy Ambrose is admitting here that Dispatcher Turner lied. It was a lie? Question. It was a lie? Answer. Yes. Deputy Ambrose answers yes, that it was a lie, that Alan Turner lied. I mean, police officers lie. Prosecutors prosecute cases illegally and unlawfully. Prosecutors delete evidence, such as the video evidence. Prosecutors will perjure themselves. Prosecutor Bruce is making our county look bad. He threw Maureen Beach under the bus, got her to sign a sworn affidavit she didn't even read. So when I got her on the stand and under oath, she tells the truth and gets caught in her lie, and I'm still found guilty and sent to jail. And that's exactly what this is all about, jailing innocent people. So pay attention to this case, because when Anthony Bruce responded, I got him to respond again. The first time we caught him lying that he didn't steal documents from Mike O'Keefe. Well, he did. And here Anthony Bruce is admitting that he prosecuted me and that he wasn't authorized, that the indictment was insufficient, and that it never existed. It did not exist. The indictment that did not exist. Bruce is arguing that he's admitting all of this because, and him stating that his prosecution was without authority means that I didn't have any rights none of my rights were at risk, and I didn't have a right to a speedy trial because I was never properly prosecuted legally and lawfully. So that's going to be a very interesting ruling Judge Church makes, because I can have my cake and I can eat it too, especially when you're not following the law. And so there you have it. These are just a couple of the topics involving Anthony Bruce and the corruption going on in Orleans County. I'm going to be suing Anthony Bruce specifically for this prosecution that he admits was legally insufficient. And so Prosecutor Bruce isn't protected by immunity because he didn't qualify. He wasn't qualified. He wasn't authorized. He lacked jurisdiction and authority to prosecute me, yet he did in open court in front of Judge Church under the color of law, and Judge Church allowed it. Therefore, Orleans County will also be sued. Anthony Bruce, we don't have to worry about immunity arguments because we got you in an open and closed case right here in Orleans County. So People versus Hardin never happened. It didn't exist because Anthony Bruce handled it. Any indictment or any traffic tickets from People versus Hardin are insufficient on their face. Gainestown Court doesn't have jurisdiction, and that's also an illegal prosecution. Thank you for watching and for hanging in there. This is exhaustive, but these are the facts. This is the proof, and this is the foundation I'm standing on in my lawsuit against Anthony Bruce. I don't have to worry about the immunity issue anymore because Bruce fell for it again and responded, except this time Bruce admits to every single one of my arguments. Take care, Bruce. This is how the law really works. It's not what you know, it's what you can prove. Take care, sir, and I will see you in court. Bye for now.